is going to be the first of 3 video arguments today, and this is State versus Brantley. Each side will have 15 minutes to present their argument, and the appellant may reserve up to 5 minutes. I just want to remind you, if you are not the one arguing, to please mute yourself so that we won't hear any background noise. And then also, we would like to make sure that you don't mention the names of any victims or any children, any minors as well. This is being, as you know, video cast over Facebook and over, just online. So if you could please abide by those requirements, we'd appreciate that. And the court is ready to proceed, if you're ready to proceed.
Yes,
so Ms. Burns, are you ready to proceed? Okay.
Yes.
Would you like to save some time for rebuttal?
Yes, 2 minutes.
Thank you.
May it please the court, my name is Rachel Burns on behalf of petitioner appellant Derrick Brantley. Mr. Brantley is a man who faces life in prison without the possibility of parole, based on a conviction obtained by the state due to suppressing evidence. Now, the state has already conceded that it committed a Brady violation here by withholding evidence of a deal it made with a key witness. The only issue for the trial court, and the only issue for this court today, is whether that Brady violation was material at Mr. Brantley's trial. Notably here, the misconduct was more than just withholding evidence. The misconduct involved knowingly eliciting false testimony from a witness during trial about a deal that the state had made. The United States Supreme Court has held that in situations where false testimony is not corrected, or as here, knowingly elicited by the state, that a more defense-friendly materiality standard applies. In those situations, materiality can be shown when there's any reasonable likelihood that the false testimony could have affected the judgment of the jury. Here, the trial court did not apply that more defense-friendly standard and instead applied the general Brady standard, which requires a reasonable probability that the result of the proceeding would have been different. Before getting into the more defense-friendly standard, it's important here to acknowledge that the state has conceded that it committed a Brady violation by withholding evidence of a deal. And this is important because in the state's brief, it claims on multiple occasions that there was not actually a deal between the state and the key witness, Anthony Townsend. And this conflicts not only the evidence presented during the post-conviction hearing, but also with the stipulation that the state entered into during that hearing. During Mr. Brantley's trial in 2014, the state called Anthony Townsend as a witness to testify on many important issues, most notably placing Mr. Brantley and his co-defendant, Mr. Haywood, at the scene of the crime. In addition, Mr. Townsend testified that he was with 2 of the victims earlier that night, and he was able to place Mr. Brantley and his co-defendant together. Mr. Townsend, he was serving in a prison time for a crime committed after the killings in this case. And the state of Ohio worked with him prior to his testimony and agreed to provide him judicial release if he testified for the state during Mr. Brantley and his co-defendant's trial. But the state did not inform Mr. Brantley or Mr. Haywood's attorneys of that deal. Rather, during his testimony at Mr. Brantley's trial, the state asked Mr. Townsend to confirm that he was not cooperating with the state and that there was no deal. And Mr. Townsend said, no, there's no deal. The state
Counsel, I know there's already stipulations, as you've indicated, but was the testimony actually inquiring as to whether he was cooperating, or just inquiring as to whether there was an actual deal or anything had been promised to him in regard to his testimony?
During trial, the question that the prosecutor asked was to confirm whether he had received any consideration in exchange for his testimony. And Mr. Townsend stated that no, he did not. And that was in fact false, because after he provided a similar testimony during the co-defendant's trial, he was walked across the hall of the courtroom and was immediately granted judicial release. So he walked in to testify as a prisoner, and he walked out free and on judicial release. And when Mr. Brantley, when his co-defendant found out about this, moved for a new trial, and the state agreed to give Mr. Haywood a new trial. But when Mr. Brantley moved for a new trial, the state refused to provide the same consideration. And it wasn't until...
Counsel, I was just going to ask you, in regard to Mr. Haywood, my understanding is that Mr. Townsend actually placed Mr. Haywood in the apartment at the time of the murders, whereas Mr. Townsend did not put Mr. Brantley in the apartment at the time of the murders, or the house.
So that's a good question. The testimony that Mr. Townsend provided was based on a telephone conversation that he had with one of the victims who was at the house. And the victim, she referred to a nickname of Mr. Haywood. However, it hasn't been disputed that Mr. Haywood and Mr. Brantley were together. There's other evidence in the case that places them together. So there really is no dispute that when he's referred to Haywood being at the scene, that it was also referring to Mr. Brantley. And that evidence was presented in the same way, both at Mr. Haywood and Mr. Brantley's trial. So really, when Mr. Townsend's testimony, it provided the same effect at both trials. And during the post-conviction hearing, finally, 5 years after the deal and after Mr. Brantley's trial, the state conceded that it did commit a Brady violation by withholding evidence of that deal it made with Townsend. So the only issue was whether that was material. Now, in situations where there's false testimony as opposed to just withholding evidence, the Supreme Court enumerated in Giglio a more defense-friendly standard. Specifically, under Brady, under the general line of case law, the defendant must prove a reasonable probability that the results of the proceeding would have been different. And that's admittedly a very high standard to meet. But under Giglio, when there is when the state fails to correct false testimony, it is whether there's any reasonable likelihood that the false testimony could have affected the judgment of the jury. Now, in the state's brief, tries to claim that there was no false testimony, which contradicts the stipulation, and tries to claim that the facts of Giglio were different than the facts here. But really, Giglio is directly on point. In Giglio, the witness that was testifying, he had made a deal with one prosecutor in exchange for his testimony. And when he was testifying on the stand, a different prosecutor asked whether there was a deal, and he said no. That's the same thing that happened here. One prosecutor promised Mr. Townsend a deal. A different prosecutor asked him on the stand to confirm that there was no deal. And the US Supreme Court said that it didn't matter that it was different prosecutors. It didn't matter that the prosecutor who asked the question during trial, if he didn't himself make the deal or if he didn't himself know. The question is whether the prosecutor's office as a whole knew. And here, that is exactly what happened. It was the duty of the prosecutor's office to know about that deal and to ensure that false testimony was not given.
You've indicated that there was a stipulation by the state, yet wasn't there testimony by the prosecutors in the case that they would consider judicial release as opposed to promising judicial release? Go ahead.
Yes, that testimony of the prosecutors was given, and that was prior to the stipulation being entered into. So the testimony of the prosecutor, while it is relevant to provide some background, the stipulation is what is important here because that did concede those first two Brady prongs.
Thank you.
So under Giglio, Mr. Brantley was entitled to that more defense-friendly standard. He only needed to show a reasonable likelihood that the jury's judgment could have been affected. And the trial court here did not apply that standard. The trial court found that Mr. Brantley's case was unlike Giglio and found that he applied the more stringent materiality standard. And if the trial court had applied the more defense-friendly standard, then Mr. Brantley should have been entitled to a new trial. It should have been found that the false testimony and the withholding of the deal did affect the jury's judgment. During the post-conviction hearing, Mr. Brantley presented evidence from an expert that stated evidence of a deal does in fact often affect a jury's judgment, that a jury can sometimes be so affected by a witness that has cooperated with the state, especially a witness who didn't affirmatively tell them that it can take their entire view of the prosecution's theory. This expert testimony was unrebutted. The state did not present testimony to contradict this. Similarly, during the post-conviction hearing, Mr. Brantley presented evidence of Haywood, his co-defendant's attorney, who had tried the case twice, once without evidence of Townsend Steele and once with evidence of Townsend Steele. And that resulted in a very different strategy when he was trying the case. He was able to focus the jury on the fact that Mr. Townsend had an incentive to lie and was cooperating with the state. And the jury in Mr. Haywood's case ultimately recommended a sentence of 35 years to life in prison, and comparing that to Mr. Brantley's case where he is in prison for life without the possibility of parole. So ultimately, the false testimony did affect the judgment of the jury. And if the trial court would have applied that more defense-friendly standard, should have found that the wrongful withholding of the deal evidence and that the false testimony did affect the judgment of the jury. And unless there's further
Counsel, I just want to make sure, though, when you talk about the judgment of the jury, we're really talking about whether the jury finds them guilty or not guilty.
So while that is more of the general Brady standard, the judgment of the jury is slightly less. It doesn't necessarily have to be guilty or not guilty. It could also be the sentence, which here, the difference between Haywood's sentence of 35 years to life and life without the possibility of parole, that's a big difference. And that could be enough because in these types of capital murder cases, the jury is the one who can recommend the sentence. So the fact that one co-defendant has the possibility of being released and Mr. Brantley does not, that is material. And that is something that learning about Townsend's deal with the state that could have affected their ultimate sentence recommendation here.
Well, their recommendation is death or not, correct? That's the recommendation.
They recommended for Mr. Brantley, they recommended life without the possibility of parole. But Haywood was the same situation. Death was also on the table, but they recommended 35 years to life. And the judge ended up accepting that recommendation. So the sentence could make a difference as well as guilt or innocence. But what really needs to be focused on is the standard and that it is more defense friendly. And the trial court here did not apply that defense friendly standard. And in cases where it's false testimony, where the prosecution should know of the false testimony and doesn't correct it, a criminal defendant, especially one facing life in prison, is entitled to that more defense friendly and less stringent standard.
Of course, I was going to ask you as well. We'll look at all that, but the other thing I was going to ask you, though, according to the evidence presented at your client's trial, he was the one that pulled the trigger. He was the one that really did the murder. I mean, not that under Ohio law that both aren't equally responsible, but obviously that could enter into the sentencing.
Yes, the evidence that was presented was very similar in both cases, and there were certain pieces of evidence that pointed more towards Mr. Brantley and more towards Mr. Haywood. But Mr. Townsend's testimony was the same towards both, and both were facing the same charges, both were facing the same possibility of death and life in prison without the possibility of parole. So while the other evidence obviously is there, the fact that there was a deal with the state and that Townsend lied on the stand, that's still something that could have affected the way the jury saw the entire case. And that's something.
Counsel, you're into your rebuttal time if you want to save that.
Yes, I would. Thank you.
Thank you. Sorry for interrupting. Ms. Palmer, Attorney Palmer, you ready to proceed?
Yes.
You will have 15 minutes.
Thank you. Good morning, and may it please the court. My name is Kristen Palmer, and I'm here this morning representing the state of Ohio. In order to establish a Brady violation, you have to show the prosecution suppressed evidence, it was favorable to the defendant, and it was material. Contrary to appellant's claims in their brief, the state is not trying to relitigate the first two prongs of this test, but it does continue to dispute the materiality prong. Appellant claims the trial court applied the wrong standard of materiality, and that it should have applied the more defense-friendly Giglio standard, which requires the conviction to be set aside if there is a reasonable likelihood that false testimony could have affected the judgment of the jury. However, that standard only applies where the prosecution has knowingly used perjured testimony. Here, Townsend's testimony was not actually false, and the state has never stipulated that it was. The state stipulated that there was evidence favorable to the defendant that had not been disclosed to the defense under the first two prongs of Brady. It never stipulated that there was a promise or agreement with Townsend. During the trial, Townsend denied when he was asked whether, quote, had there been any promises or deals made to him in exchange for his testimony. In doing so, he did not perjure himself. If you look at the note on the prosecutor's file jacket, the transcript of Mr. Townsend's sentencing proceeding, no promises were made to him. Former Assistant Prosecutor Omar Sadiq merely noted that he would, quote, consider judicial release. And at Mr. Townsend's sentencing hearing, Sadiq noted that the state would, quote, revisit the idea of judicial release. But again, he said, quote, no promises. At the time, Mr. Sadiq didn't even know what case Townsend was referring to.
Counsel, I'm going to stop you here if you don't care for
Sure.
maybe a little more explanation, because I'm very confused as to what stipulations the state actually entered into. Can you tell me what the actual stipulation was?
Again,
I mean, we can look at it in the hearing, but I'd like to know if we can.
right. It was stipulated at both the PCR hearing, and then there was a document that was entered into. And again, the language is that there was evidence favorable to the defense that evidence that was favorable to the defendant that had not been disclosed to the defense. I don't believe there's any language at the hearing or in the document that was subsequently filed that says that the state ever stipulated that there was any promise or agreement that was made. In fact, Mr. Sadiq had filed an affidavit with the court at the PCR hearing confirming that he had said that he would consider judicial release. But again, he said, however, I never promised judicial release.
Well, let me ask you, I guess I'm a little confused. If the state never promised judicial release, so there was no actual promise, and you're saying it's not false testimony, why did the state enter into a stipulation that there was favorable evidence that was not disclosed to defendant? Because you're saying now there wasn't any such deal. So how would there be favorable evidence that was disclosed?
I'm sorry, Your Honor.
No, that's okay.
I think that it's still impeachment evidence that the defense should have received so that it could have come out on cross. I don't think it was a promise or an agreement to do anything, but could the defense have used it? Was it favorable to the defendant? Yes. So I think there was impeachment evidence that should have been disclosed, and that's what the state has stipulated. Sorry, because no promise.
Let me ask you, I'm sorry.
That's all right.
let me go on. So the state didn't feel that there was actually any kind of deal or consideration given to I can't even think of his name now, Mr.
Townsend.
Thank you. I kept on thinking just Brantley and Haywood's always coming to my mind, Mr. Townsend. But yet, on the other hand, whenever Haywood was tried, the state agreed to a new trial on the same basis.
Right. And I think the answer there is that the state agreed that the evidence was material in that case, because I think it was you who mentioned earlier, at Haywood's trial and at Mr. Brantley's trial, what Townsend testified to was that one of the victims had, during a conversation he had with her after dropping her back off at 42 Kimlin Circle, was that she had said she saw Doug or Dutch through the window. And one of those names was a nickname for Mr. Haywood. So there was a stronger case for materiality in Mr. Haywood's case. And that's why the state agreed to retry the case for the mistrial there.
Well, nonetheless, the state did use that testimony to put Mr. Brantley at the scene as well, since they were together earlier in evening, and circumstantial evidence, if they were together earlier, they were probably together then.
Well, I think from Townsend, though, the testimony was only that that he had seen Doug or Dutch, and he explicitly said on cross-examination that the victim had never mentioned Brantley. The witness who put Mr. Brantley near the scene of the crime was Deontay Woods, who was a longtime friend of both Haywood and Brantley. And he had testified that Haywood had called him that night and asked him to follow somewhere. And when Haywood arrived, he was with Brantley, and he followed him to Gurley Avenue near 42 Kimlin Circle, and that they asked him to park and wait there. So it was Mr. Brantley's friend and not Mr. Townsend who placed him at the scene of the crime.
Well, but Townsend then testified that Mr. Haywood was at the scene of the crime, and the jury was already given evidence that they were both together and in that vicinity where they were dropped off. So that's pretty strong circumstantial evidence that that they were both at that house based on Townsend's testimony.
It was corroborated evidence by Deontay Woods.
Okay, you may proceed.
And counsel, I'm sorry to hold you
Sure.
up just one more moment on the concept of a promise.
Mhm.
As I recall, certainly you quoted again, no promises, but didn't that testimony continue with, but now that is on the table?
Well, again,
Like with respect to judicial release?
Sure. What he said is that the state would revisit the idea of judicial release, which in reality it should do in every case when it gets the motion for judicial release.
But wasn't there also some conversation that he would not normally do that, but that it would be back on the table, judicial release?
I think he did say that when there was an agreed sentence, normally it would not be considered.
Okay, thank you.
Mhm.
And to follow up with Judge Sutton's question, wasn't it also contingent on him testifying and cooperating that he would look at judicial release again?
Well, like I said, at the time, and I think Mr. Sadiq says he didn't find out until years later what case Townsend was even talking about. Townsend had already been talking to the police. He had been cooperating. His attorney approached Mr. Sadiq before the sentencing hearing and said, hey, would you consider this? And Sadiq knew nothing of what was going on and just said, well, the state would consider judicial release, but he didn't even know what the testimony related to. And he never relayed that information, not knowing which case it related to, back to the prosecutor who tried the case. So in United States v. Bagley, the Supreme Court stated a different standard of materiality, which applies to the two other categories of cases. In those cases, the evidence, they said, is material only if a reasonable probability that had the evidence been disclosed to the defense, the result of the proceedings would have been different. Here, the state's position is the trial court appropriately applied the Bagley standard. Appellant asked this court to ignore all of the other evidence and focus on Townsend's testimony. They seem to agree that the relevant question is whether the omitted evidence undermines confidence in the outcome of the trial. But in order to answer that question, the court has to look at the omitted evidence in the context of the entire record, which is what the court said in United States v. Aguirre. The vast majority of Townsend's testimony at trial was corroborated by independent evidence. His testimony about meeting up with the victims and another person at Dreamers, leaving and going to Denny's, and then going back to one of the victims' house was corroborated by video evidence, cell phone records, and the evidence of the other man who was with him. Cell phone tower records also corroborated his testimony about his movements and that he had taken the two victims back to 42 Kimlin Circle that evening, and that he had received, there were two calls between his phone and the victim's phone thereafter. So the only uncorroborated piece of testimony was the content of those calls and whether she had told him, as he testified, that she had told him she saw Doug or Dutch, meaning Mr. Haywood or one of the victims in the case. There was also substantial other evidence presented of appellant's guilt that was unrelated to Townsend's testimony. Cell phone records demonstrated that the last incoming call to the victim's phone came from Haywood at 1:10 a.m. and that Haywood had then immediately called Deontay Woods. As I mentioned earlier, Woods testified about having followed the men to 42 Kimlin Circle. He said the two men, Brantley and Haywood, later ran up from behind his car and got in, that Mr. Brantley was carrying a wrapped up white t-shirt and a bag he believed contained heroin, and that one of the men had then warned him to, quote, take it to our grave or I'll kill you. And that Brantley had said that he had doubled back to make sure everyone was dead, which I think is the evidence you're referring to. You referred to earlier about Brantley being the actual shooter. And more of that evidence was that the cell phone records for both Haywood and Brantley showed messages between the two that evening. There was a message from Brantley's phone to Haywood's phone at 2:10 a.m. saying, quote, kill both of these, an N-word, which had been deleted from Brantley's phone before he turned it over to the police. The records showed a second message from Brantley's phone to Haywood's phone at 2:48 a.m. saying, quote, I'm about to shoot Dutch, go get that shit, but you got to hurry up so we can get up out of here. What all this evidence shows is that this and other evidence is that the omitted evidence about Townsend's judicial release does not undermine confidence in the outcome of the trial. Even assuming that the trial court applied the wrong standard and it should have applied the Giglio standard, the appellant's claim should still fail. Again, this case is distinguishable from Giglio, where the Supreme Court said that the government's case against the defendant there, quote, depended almost entirely on Taliento, who was the key witness, testimony. Without it, there could have been no indictment and no evidence to carry the case to the jury. Taliento had been the defendant's co-conspirator. In Giglio, he was the bank teller who had cashed the forged money orders, and he was the only one who linked Giglio to the crime in that case. By contrast here, there was overwhelming independent evidence of appellant's guilt presented at trial. Appellant asked this court to ignore all that evidence and focus on Townsend's testimony. The state submits that's incorrect and instead urges the court to follow the Supreme Court's approach in Aguirre's, requiring that the omitted evidence be considered in the context of the entire record. To reach the opposite conclusion would require the court to ignore all the other evidence in this case and place undue importance on Townsend's testimony. The state doesn't have anything further at this time unless the court has additional questions.
It appears that we don't. So thank you very much for your presentation.
Thank you.
And Attorney Burns, you will have just a little over a minute left.
Just one brief point. Despite the state saying that they did not intend to relitigate the first two prongs, that's exactly what they did. As both your honors acknowledged, the sentencing jacket and the affidavit entered by the prosecutors stated that they would consider judicial release for Townsend if he cooperated in testifying against Mr. Brantley. That is a deal, and that is what the state ultimately conceded to in its stipulation. Because of the false testimony, the trial court should have applied the more defense-friendly standard. It did not. So almost that Mr. Brantley is requesting here is that this court remand the case back to the trial court to apply the correct standard and determine materiality based on whether the false testimony could have affected the judgment of the jury. Thank you.
Thank you. Thank you both for your presentations this morning. They were appreciated. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as, you know, we release them online at our website, and the Supreme Court releases them as well. So please have a good day, and thank you for appearing via video this morning.
Thank you.
Thank you.